I hope from my topic today that you'll be equipped with arguments and defenses to put to SARS when you need to challenge their procedure. Because the last 2.5 days have been devoted to unpacking the Tax Admin Act and the respective rights and remedies for taxpayers. But my topic focuses specifically on the Constitution and the taxpayers' rights that flow therefrom. And so naturally there's going to be a little bit of overlap with some of the previous speakers' topics. I will try not repeat a lot of what they've said, but just bear with me insofar as there is a bit of repetition. So as a starting point, let's consider the Constitution and the relevant sections contained therein. By this stage, we now know that SARS's conduct is governed by the Constitution. This means that SARS has constitutional obligations in terms of Section 1C, Section 2, Section 41, and Section 195. And these give rise to a series of duties. Non-compliance by SARS with these duties, or these constitutional obligations, will in turn give the taxpayer a right to enforce these constitutional obligations. So let's delve into what these constitutional obligations are. And we look to Section 195 of the Constitution. And that states that public administration must be governed by the democratic values and principles enshrined in the Constitution and Bill of Rights, which include the following: displaying a high degree of professional ethics, giving services that are fair, equitable, impartial, and unbiased, responding to people's needs, displaying transparency and accountability. And these principles must be read with Section 1C, which says the Constitution and the rule of law is supreme. Now, I've been listening to the speakers over the period, and a number of them have mentioned this concept, the rule of law. I'm not sure if you guys understand this concept, but it's very important for this particular topic and as an argument in general when you are challenging SARS's procedure. And it's very simple. Essentially, the concept, the rule of law, means that all government action must comply with the law, including the Constitution. Okay, so park that there. If we expand on this, it means that SARS can exercise only those powers lawfully conferred upon them. And by an extension, this means that compliance with the Constitution is the starting point of compliance with the rule of law. And conversely, non-compliance with the Constitution means that SARS has acted unlawfully and ultra vires, meaning beyond the scope of the Constitution. And in terms of Section 2 of the Constitution, conduct which is unlawful and inconsistent with the Constitution is invalid. And invalid conduct is capable of being set aside entirely. Now, in circumstances where SARS fails to comply with the rule of law, the remedy is based on the principle of legality. Now, I know this is sounding very academic at the moment, but there's just two primary concepts I want you to grasp, and then I'm going to explain them to you in a case study to see how they actually are implemented in practice. So the one is the rule of law, and the remedy for the rule of law is housed in what's known as the principle of legality. And I think Daniel also mentioned this, and I think Judge Davis mentioned this principle of legality. And what this concept means is that public power must be exercised in accordance with the law. If SARS's conduct falls outside the powers that are given to it by relevant statutory provisions, then it is unlawful and unconstitutional. And once again, unlawful, unconstitutional conduct is invalid. Now, this principle of legality can, in certain circumstances, constitute a safety net when PAJA is not available. And I'm going to come back to that in a bit. Let's move on to Section 33 of the Constitution, which deals with Just Administrative Action Act, and says that every person has the right to administrative action which is reasonable, lawful, and procedurally fair. I'm sure this has been drilled into your heads by this stage of the conference. PAJA is the national legislation which gives effect to the rights in terms of Section 33. And it equips taxpayers with rights that it can challenge SARS's procedural misconduct. not necessarily focusing on the technical issues of a case only. So let's consider PUDGE in a little bit more detail. I know Judge Davis spoke on this, but I just want to highlight a couple of salient features. To recap, what is administrative action? It's a decision or a failure to take a decision by an organ of state, such as SARS, which adversely affects the rights of any person and which has a direct legal external effect. PUDGE explains at Section 3 that administrative action must be procedurally fair. And there is no definition of procedural fairness in PUDGE. It depends on the facts and circumstances of each case. However, Section 3b gives the organs of state constitutional obligations to stick to ensure that procedural fairness is actually adhered to. Let's take a couple of these subsections and compare them to the Tax Administration Act, in which SARS has tried to encapsulate some of these steps. For example, Section 3BA says that adequate notice of the nature and purpose of the proposed administrative action must be given. So if we look at Section 42, we see that SARS, at the end of their audit, need to keep taxpayers informed by giving them their findings. And this is what I call a letter of findings. PUDGE says a reasonable opportunity to make representations. So in that letter of findings, SARS ought to give the taxpayer a reasonable opportunity in which to respond to those findings. A clear statement of administrative action, well, this is, we know, is your assessment. That is SARS's decision, and that constitutes administrative action. Adequate notice of any right of review or internal appeal where applicable. Well, in your assessment, the taxpayer is given an opportunity to object within 30 days. And finally, adequate notice of the right to request reasons. Again, in your assessment, the taxpayer is given an opportunity to request reasons within 30 days. And that's in terms of Rule 3 of the rules pertaining to objections, appeals, and ADRs. So from the Tax Admin Act, we see that it's mirroring Section 3B of PUDGE. And so the bar has been raised quite high for SARS to give effect to procedural fairness. And what I observed yesterday is a lot of the audience members were complaining that notwithstanding these duties contained in the Tax Admin Act, SARS are not adhering to them. So there's a failure from the SARS auditors to give the letter of findings. But I draw your attention to one of the codified grounds in PUDGE under Section 6, which says that administrative action is reviewable on this ground: non-compliance with a mandatory and material procedure or condition. So I can tell you now, if you did not get that letter of findings from SARS, if you wrote a letter back to SARS drawing their attention to that Section 6 and that specific ground and saying you have failed in your procedural fairness because your administrative action did not comply with the mandatory process of informing the taxpayer in terms of Section 42, I can tell you now, SARS will sit up and take notice. So I know one of the sort of criticisms of review applications and having these great fundamental rights is running to the High Court and it being a costly exercise. But sometimes the threat has more weight behind it than actually the implementation thereof. And especially if an auditor receives a letter with, that sort of content in it, they'll sit up and take notice. They'll think, hold on a sec, we have maybe missed a step. Let's just go back to the drawing board. Let's hold our proceedings in abeyance whilst we get the procedure back on track. So that's just some food for thought in how you want to handle that process or any particular procedure which has been bypassed by SARS. Just alert them to what they were supposed to do in accordance with PUDGE. Now, turning back to the reasons, Mr. Gadd, Robert, spoke yesterday of the two strategies of requesting reasons. One was buying more time, but the second one, which is the more important one, is actually getting SARS to bed down their actual reasons for their decisions, and hopefully ensuring that these are the reasons that are maintained throughout the process, the dispute process, which might eventually go through to the litigious forum, being the tax court. So my suggestion would be, and in accordance with Mr. Gadd's always request reasons, because it is the starting point which for potentially what could be a long road ahead. And as I said, it ties SARS down to the grounds of assessment, which should be the same grounds at the tax court stage during the pleadings phase when it files its statements of grounds of assessment. But what about other administrative action of SARS? We see that when it comes to an assessment, you're entitled to reasons in terms of Rule 3 of the rules. But what happens if you want other reasons for another form of administrative action? Well, here your right lies within Section 5 of PAJA. That gives every person a right to request reasons within 90 days from the administrative action. This is a very, very powerful tool. So know that that general right has been legislated in terms of Rule 3, but only insofar as it pertains to assessments. If there's another form of conduct, a decision which constitutes administrative action, your right to request reasons is in terms of Section 5 of PAJA. And I always say, even if a taxpayer is uncertain of that conduct constituting administrative action, but wants to understand how SARS arrived at the decision or just get a better understanding, rather request the reasons, rather invoke that right in terms of Section 5 and refer to it so that SARS understands where you're coming from, and let the ownership to SARS to explain why it isn't administrative action, and therefore they're not obliged to furnish adequate reasons. Because that reason, well, that explanation from SARS' side might not be sound, and so their conduct might very well constitute administrative action, and so a taxpayer might very well be entitled to reasons. And once again, I always say rather be prudent and err on the side of caution. If you want reasons and you think you might be entitled to, why not? You've got nothing to lose. Because if you don't use your right, you lose your right. You have 90 days to invoke Section 5, the request for reasons, and you'd be amazed at how quickly 90 days goes whilst you're debating whether SARS' conduct is actually administrative action, whether I can actually ask for the reasons. Just ask. You've got nothing to lose. That is also legislated in PAJA. They've got 60 days within PAJA under Section 5. Okay, once again, the codified ground is failing to take a decision or failing to give adequate reasons. That is actually a ground within PAJA, the failure to give adequate reasons. Another thing that I said before, non-compliance with a material or mandatory process, condition, procedure. These are all phrases that are housed under Section 6 of PAJA. You'd be amazed at what Section 6 actually encompasses. So if they don't, you can write back and say within PAJA, in terms of PAJA, you are obliged to respond. You have failed to do so. And I always do this when I write a letter. I say, I'm giving you until close of business on X day, failing which our instructions are to launch the appropriate review application to have your decision set aside. Because in the absence of adequate reasons, SARS or any organ of state or an administrator is found to have made that decision without just cause. And any decision arrived at without just cause can be set aside or remitted back to the Commissioner for reconsideration.
When you request their reasons for them issuing an assessment, let's say, you have a specific period of time to lodge an objection. So
Okay.
I'm concerned that you send them this letter, they don't respond, and then you're out of the time to lodge an objection. So should it go with an objection?
No, your right to request reasons suspends the time period of an objection. The objection period is held completely in abeyance, pending the receipt of reasons. And that's why I said I referred to Robert Gadd's two strategies that he highlighted yesterday. The request for reasons is often used to buy additional time because suddenly 30 days, it's day 29 and the objection hasn't been lodged. You put in a request for reason, it suspends that until you get the reasons back from SARS. You don't have to lodge an objection. And then once you do, the 30 days recommence.
Yes. My understanding is that all the IT 34 come with reasons. And I think quite a few of those myself. They all come with reasons. But I think we're missing the point here. The final SARS is giving you the reasons instantly.
But sometimes those reasons are not adequate. Let me explain that although there's not a definition for adequate reasons, sometimes what I'm noticing is SARS merely cites the section that they're relying on for that assessment without applying it, okay? Now, when you look at previous cases, judges have held that an adequate reason must put you as the taxpayer in a position to say, even though I don't necessarily agree with SARS's decision, I understand how they arrived at their findings. Now, I don't know if the grounds that you were given in the IT 34 would equip you with that, but I know that the reasons that I'm getting a lot of the time are merely citations of sections, and it hasn't been applied adequately to the facts of that particular case. And so, if you're entitled to that right, even if you are given the reasons, to the extent that SARS feels those reasons are adequate, they will turn around within the time period and say, you have been given adequate reasons. And then you can either decide whether you want to take that further and challenge that adequate reasons and dispute it, or if you say, all right, it's acceptable, my strategy was merely to buy time, so I'm not going to pursue this.
The field I see, we came to the conclusion that the taxpayer submit all the items to file. So the reason that they gave us in that thing was quite acceptable. And they said under declaration of income, and then precisely the taxpayer has submitted all the items to file.
Well, that's
And you know what I thought then? Instead of asking for reasons, because the taxpayer was eligible for a refund. So instead of applying for reasons, saying delaying time, you gotta comply and submit all the information and get to the refund quicker. You see my point?
No, 100%. It depends on what strategy you're trying to pursue. You know, if you want to just finalize the outcome of the investigation or the audit or the assessment, it depends. It must be treated on an ad hoc basis. That's why I'm saying what are the two strategies of requesting reasons. One would be to buy time and one would be to actually get actual reasons insofar as there aren't any. But if you got and you were happy and you knew what to do next and you could finalize the matter, great. Just depends on each case. It must be treated accordingly. Okay, so now an interesting issue which I heard Judge Davis touch on is what theory supports administrative action. And I know this is quite academic, but I just want to give you something to chew on, food for thought. And he said it was the determinative theory versus the deprivation theory. SARS would argue, and rightfully so if I was SARS, that administrative action is supported by the deprivation theory, which means only the deprivation of your rights constitutes administrative action. But Judge Davis supported the determinative theory. And insofar as that is actually plausible, then one could possibly argue that SARS's decision to conduct an audit on a taxpayer constitutes administrative action, and one which you could request reasons for. So I know that would open a complete can of worms, but typically I'm sure taxpayers think that they can't ask reasons when they receive a notice from SARS informing them that they're going to be audited. But if we look at that theory as what Judge Davis spoke of, the determinative theory supporting administrative action, it is a decision. Could it constitute administrative action? If so, you're entitled to request reasons, which means the taxpayer would be saying, no, I want to know the purpose and object of you wanting to conduct this audit on us. What are you looking for? Is it a fishing expedition? Do you have something in mind? What are the taxes under investigation? Potentially narrowing down the scope of that audit so that ultimately the taxpayer can work in conjunction with SARS to expedite it. Anyway, that's a topic for another time. As I said, remember, if you don't receive reasons at all, and if you don't receive adequate reasons, then your right is to take SARS on review. And your remedy by the courts would be either remitting the matter back to the Commissioner for reconsideration or setting aside the decision entirely. Very powerful remedy, that. Okay, then quickly, Section 6, as I said, those are the codified grounds on which you can take a matter on review. Have a look at them, familiarize yourself with them. They do actually cover a lot. And the procedure on how you launch a review application is then given under Section 7, and you have 180 days from the date a decision is given, or the failure to take a decision, in which to launch a review application. And remember, time flies. So you think 180 days is a lot and you're debating whether you should go that route. Suddenly, it's over and you've got to prepare pleadings. And it is a litigious matter, so a lot of thought and preparation needs to go into that application. So be mindful of the time constraints there. Another thing I want to draw your attention to is you have to exhaust the internal tribunal first and foremost, insofar as there is one. So obviously within SARS, we know that there's a tax court. You would need to use that as your first port of call, unless there were exceptional circumstances, in which case you could bypass the tax court and go to the High Court. And I just want to sidetrack here. Again, I'll refer to Judge Davis's comment where he said that because SARS is a creature of statute, they derive their powers from legislation, which is correct. And so SARS cannot get their powers from the regulations, which says you can take a review application to tax court. But I just spoke to Berek because I don't necessarily agree with that. The regulations, being the rules pertaining to objections, appeals, and ADRs, are actually read into a tax act. Okay? So that forms part and parcel of a statute. And him and I are on the same page where we agree that your internal remedy is the tax court, and you would need to use that first before going to a High Court, unless, like I said, there is merit to go to the High Court. Unfortunately, with the tax court, it takes ages to get a date, and the High Court is more expeditious. And so we've actually used that as one of the grounds to circumvent the tax court, to say, you know, we want to object on the technical merits, but before we go there, we need to exhaust the procedural aspect because it could make or break the case. And if we win on SARS's invalid conduct, then we don't even have to look at the technical issues. So when you challenge SARS, a lot of the time it's a two-prong approach. It's not just on the substantive technical points. It could be on the procedural irregularities, in which case you have the Constitution and PAJA on which to fall. Okay, so with the development of the constitutional law, we see the promulgation of PAJA, which gives effect to Section 33. And as I said, the provisions of PAJA must first and foremost be considered when you're taking SARS on review and initiating procedures against SARS for invalid conduct, because PAJA regulates administrative action. Now, if PAJA doesn't apply, okay, for instance, where there's conduct that does not fall within the definition of administrative action, then the other avenue of review available to the taxpayer lies within the principle of the constitutional principle of legality. Okay, that is your backup plan. And the principle of legality oftentimes fills the loophole when PAJA doesn't apply. Okay, so now I know that sounds all pie in the sky, so let me use an example to better illustrate this. Consider the scenario that Robert Gadd illustrated yesterday, which was actually in a few of his cases, and these facts are identical. This is actually an unreportable High Court judgment that was given recently. Okay, so the Commissioner introduces a brand new ground of assessment in the Rule 10 statement. You know that the Rule 10 statement is now at the commencement of the pleadings when a case is going to tax court, and SARS are obliged to give their statement of grounds of assessment. And now they introduce a fresh ground which has never been seen before, not in the assessment, not in the reasons, not in the disallowance of the objection. So the taxpayer brought a review application based on two remedies. The first was in terms of PAJA, to have SARS's decision to introduce a fresh ground of assessment set aside. And that was based on two of the codified grounds under Section 6. It was F, subsection F, which says the action contravenes a law or is not authorized by the empowering provision, and subsection I, which says the action is unconstitutional or unlawful. And in the alternative, the taxpayer sought a declarator that the Commissioner's decision to raise the ground was invalid on the basis of the constitutional principle of legality. Okay, so now this is a perfect scenario of where both these remedies PAJA, and the Constitution, the rule of law, are running contemporaneously within one application. Now, the judge found that SARS's inclusion of the new ground in the Rule 10 statement did not constitute an administrative action. The judge was of the view that it didn't constitute a decision as defined in PAJA, and therefore could never fall within the definition of administrative action. Instead, the judge explained the reasoning was as follows, and I'm going to just read a portion of the judgment. SARS is obliged, in terms of Rule 10.3 of the Tax Court Rules, to deliver to the taxpayer a statement of grounds of assessment, setting out a clear and concise statement of the grounds upon which the taxpayer objection is disallowed, and to state the facts and the legal ground upon which the Commissioner relies for such disallowance. It could be argued that such action is not an administrative action as defined, but rather a legal requirement obligating SARS to do something. So PAJA is thus not applicable. However, the constitutional principle of legality can be relied upon. The inclusion of the new grounds in Rule 10 fall outside the powers given to SARS in terms of the relevant statutory provisions, and is therefore contrary to the law and the principle of legality. So from that case, one can actually see how powerful the principle of legality is, and how it provides a much-needed safety net when PAJA doesn't apply. Just checking my time. Bear in mind that you cannot circumvent PAJA and go directly to Section 33 and rely on the rule of law and the principle of legality. You have to first exhaust PAJA and determine if that action constitutes administrative action. Then you launch the application in terms of PAJA first, and in the alternative, plead the principle of legality. So in practice, the first inquiry as to the reviewability of SARS's conduct, to the extent that you might perceive it to be invalid, would be to determine whether the conduct constitutes administrative action, and if so, your remedy lies within PAJA. But to the extent that it doesn't satisfy one of the codified grounds under Section 6, or it doesn't constitute a decision and therefore administrative action, then you look to the constitutional principle of legality. And I would submit that SARS's failure to adhere to its constitutional obligations would be a transgression of the Constitution, and immediately allow you the right and the remedy to approach the court to have that conduct set aside on the basis that it is unlawful and inconsistent with the Constitution, and in accordance with Section 2, unlawful, inconsistent with the inconsistent or unconstitutional behavior is invalid. Okay, I'm not going to take any more time. I just want to summarize. Just remember that based on the topic I've given you, the Constitution read together with PAJA, they work hand in hand, and when you are looking at how to challenge SARS, you have both, but first and foremost, to determine if it is applicable in terms of PAJA and administrative action, and if it's not satisfied in terms of PAJA, your recourse lies within the principle of legality. Okay, lastly, the last section of the Constitution I want to refer to is Section 32, the Access to Information Act. Again, you can see how the principle of legality can be used if you cannot enforce your rights in terms of what's available to access information. Okay, so for example, let me just give you an illustration of this. If a taxpayer requires records that are in SARS's possession, their rights to obtain same are within Section 32, being the access to information, and look to a brochure or a manual or guide, I don't know what SARS calls it, on their website. It's a very user-friendly, self-explanatory guide, and it explains what the internal remedy is if you want to request access to SARS's records. You fill in Annexure A, I think it's called Form A, and actually it's called Access to Records. It's easy, you tell them what you want. It goes to the information officer at SARS. They consider it and either tick the box yes and give you their records, which I've never received. I've always been rejected for my requests. But if your request is rejected, then you have the internal appeal, and that's a Form B, and you lodge that obviously taking that decision on appeal. That gets sent to a third-party mediator, for lack of a better word, who considers the request as request and SARS's information officer decision to refuse it and gives their decision on appeal. If the appeal is disallowed, then your rights to recourse are reviewing that decision by way of a High Court application. Okay, so exhaust the internal remedies. Like I said, it's available on SARS's website. Thereafter, you can go to the High Court. And remember, Section 195.1, one of the constitutional obligations is transparency. So SARS is actually obliged to tell you what they have in their possession. And if you cannot get that by way of this internal remedy, then your other remedy is principle of legality, SARS's failure to adhere to one of its constitutional obligations being transparency within the Constitution, that being contrary to the rule of law, and your remedy being the principle of legality. Any questions?
Any questions?
Any questions? Because before Stian comes back and like monopolizes with his topic.
I'm here to facilitate the questions.
Okay.
Any questions? I think, Kerry, this maybe from my side, I think being a studied attorney or a graduate or attorney tax lawyer, what is your experience in terms of general disputes? What I'm trying to get to is, should one first try to even rectify and remedy the matter or dispute or problem or process using the unofficial routes, for example, access to information? Because once you, in my experience, once you go to that process of using the law to get information, then immediately the other party, whether it's SARS or whether it is whoever, sense that you actually on your route to litigation, and immediately you get a pushback.
Yeah, you know what? People are scared of attorneys because they think we always run off to court. And that's a very good question, because I always play good cop attorney. I think rather cooperate with SARS in an effort to reach resolution of a matter. And when clients come to me and say, I'm so sick of this harassment, on principle I want to take SARS on, I said, you don't litigate because of principle. Believe me, it's expensive, it's emotionally draining. I'm telling you, by round 3, because it's not just ADR, it's tax court, it's high court, suddenly it's Supreme Court of Appeal. You are so exhausted, you're thinking to yourself, why did I ever go this route? So always, my first port of call is to try and resolve something amicably and expeditiously. Okay? To the extent that there are internal remedies, you are obliged, actually, as a taxpayer, to exhaust them first and foremost. So not even wearing my attorney's cap am I saying you should do that. I'm saying that legally, that's what you need to do. But secondly, as the taxpayer, it's more beneficial for that person if you can not incur those huge fees, those litigious fees. And oftentimes, when taxpayers say, oh, ADR is a waste of time, they're going to reject our offer anyway, I say, you know what, let's just run through the process, sit around the table. SARS also doesn't want to run to court. It is expensive. It is hugely draining on resources. So let's try and bed it down at the first chance we get, rather than now we're in a litigious forum. So definitely, Stian, my advice would be err on the side of friendliness if you can, and try and resolve it internally before.
And keep emotions out of it.
Yeah, sometimes when I've got an emotional taxpayer client, I tell them to stay at home. Because, you know what, I can see, as the practitioner, you can see the wood from the trees. They are the ones that have been emotionally invested in it, but you are the ones who actually know that they don't have the best case necessarily, maybe. And by them shouting the odds, it's only going to get SARS's back up, because at the end of the day, SARS has personalities, and they're also human beings, and they also want this file off their desk that's also been dragging on for 5 years. So, yeah, I always say keep emotions out of it.
Thank you.